where I'm from. I'm from the law firm of Kain Burke. The law firm has been in town over 30 years. We've been in the Alpine Bank building downtown forever, and then we just moved up off of Horizon Drive. Kain, Will Kain, some of you may know the name. He used to be the district attorney in town. He just recently retired. We kept his name because we like him. But today we're going to talk about end-of-life planning, estate planning, all of the things that go into that. And the way I like to talk about that is in two different ways, okay? Well, three different ways. We have, a lot of us have stuff that we want to pass on. Even if we don't have stuff, we still need to plan for our end-of-life things, right? We need powers of attorney in us, so we'll cover all of that. First off, I want to tell you about the descendancy, passing property. Okay? People usually think of when they're doing an estate plan, they usually think of a will or a trust. I'm sure you guys have all heard about those. But they fall into two different categories. I'm going to call them testate and non-testate. Okay, testate, we'll do over here. And over here we'll do non-testate. I'll start with testate because that's the easier side. It's short. Okay, it's less complicated. Testate. Does anybody know what that means? Testate. Well, what do you do? You create a last will and testament, right? So testate is wills. And that's it. That's it. In wills, who here has a will? All right, we got about 40% of you guys have wills. Now let me tell you something. The state of Colorado is an awesome state for a lot of reasons. We got beautiful natural resources. We also have some decent laws. Our legislature has done some good things to make it easy for us to live our lives and administer our lives. One of the things they've done is they've written a will for all of you guys. So you all have a will. So if you're asked again, does everybody have a will? Kind of, right? The state does say if you die without a will that you've executed yourself, that your property will pass by a certain structure. It's called intestate succession. This is testate. We've got intestate succession. Where you don't have a will. What happens with intestate succession? I'm sorry, we'll get to that. We'll stay over here on this side. Wills, you know what a will is. You want your property to go to certain people. Right? So you say, I want all my stuff, like my dad. My dad wrote his will, he hand wrote it. It's awesome. So I come from a family of doctors. And they all think they're never gonna die. My dad had a couple heart attacks and strokes in a very short period of time. He was in the hospital. Didn't have his estate plan. I've been after him for a while. And so I drafted an estate plan for him real quick and he signs it, but he wasn't really satisfied with it. So later on, he just handwrites one out in pencil, which you shouldn't do, and mailed it to me. And in it, he says something like, I leave all of my earthly possessions to my lovely bride, Audrey, my mother. And that's what a lot of people do. They just leave all their stuff to their spouse, their husband, or their wife. They don't have a spouse, or if their spouse has already passed away, they typically leave everything to their kids. And you know what? That's what the state says is going to happen if you don't have a will. Okay, not much different. But one of the things that you can do in a will that the state doesn't do is it nominates who's going to represent your estate. Who's going to administer your estate? You guys have kids, you know some of them are responsible. Some of them are irresponsible. Some you trust with money. Others you can't trust at all with money. Like you. Specifically talking to this. Some of them can make good medical decisions. Some of them have no idea what decisions to make. And so when you create a will, you can say, I want this child to get this property, this child to get this property, this spouse to get this. And I want this person to handle the financial affairs, because they're a responsible person. It might not be your spouse, right? It might be your oldest son or your second daughter or something like that. Hey, typically, I don't know what it is, it's usually a daughter that's the responsible one who steps in and says, I'll handle this. But you guys can determine that in a will. If you don't have a will, who's going to administer your estate? Well, the state, not the state, it's not the state. The state said, because they don't want to do it. Right? They don't want to get into your guys' business and go through your house and say, okay, well, what are you going to do? The state has said the first person in priority is the spouse. The spouse gets to administer. After the spouse, it's the children. And what if you've got 5 kids? Well, that's an arm wrestling match. Right? Who's going to represent the estate? There might be some argument. And once there's some argument, where does that end up? In court. And if you're in court, what happens to your estate? It starts to go like this. It gets smaller and smaller and smaller the longer you're in court, because it costs money and it takes time. You don't want to do that. So I always encourage everybody to do a will. It's pretty simple, very straightforward. Just do it. If you don't have a will, we started talking about intestate succession. Your property's going to go how the state says it's going to go. It's going to be administered by who the state says it's going to be administered. And that might be determined by statute, or it might have to be brought out in courts. Okay. Wills are pretty simple and straightforward. If you want to do something a little more complex, we'll talk about trust. Right? There are lots of different trusts you can do. Yes, ma'am.
On the will,
Yep.
is that something that you can just have notarized, or do you have to go through an attorney?
Thank you. So, wills are one of those things that have very specific statutory requirements for execution. By execution, I mean signing. Okay. No, you don't have to go through an attorney. They do have to be either notarized or signed by 2 witnesses. And what we do at our firm, we know that litigation costs a lot of money. So our main goal is to plan the way people want planned and keep them out of court. So we do what I call the belt and suspenders approach. Usually belt's enough, or usually suspenders is enough. Put both of them together, your pants are falling down. Right? You're not going to end up in court if you've got a belt. And so we'll do 2 witnesses will sign, and we also have a notary sign. So if there's any dispute about the witnesses, or dispute about the notary, yes, wills have formal execution requirements. You don't have to do it through an attorney. The reason an attorney is advisable in a lot of cases is because sometimes you might want something that's illegal. Okay? And we want to keep you out of court. Let's say you're on your second marriage, right? And you have 3 kids from your first marriage, no kids from your first marriage, and you say, I want all my property to go to my 3 kids, not my new spouse that I've only been married to for 2 years. I've seen this a lot of times, people who are, I had a guy who was 89 years old. He'd been married for over 60 years and his wife passed away. And he met some young spring chicken who was only 76. And they decided to get married. And it was kind of a dangerous thing, right? Because now he's got all these kids from his first spouse. Now he's got a new spouse. So what's going to happen to his property? And if he said, I want everything to go to my kids, well, his new spouse might say, well, wait a minute. What about me? And it gets complicated when you get into second marriages. And what if you have kids from 2 people or 3 people? It gets really complicated. And so you might want something that ends up causing you to go to court. So if you have a plain Jane vanilla deal, it's okay to not talk to an attorney. I always suggest it just to make sure what you want is legal. If you have any complications at all, I would absolutely recommend talking to an attorney, because you don't want to cause problems for your heirs. Part of the reason you do this planning is so that your kids and your spouses don't have problems. You want to make things easy. Okay. Oh, speaking of easy, let's go over the non-testate side. I will do trusts. All right, I promised I'd write Lenny's leave, and I already went back on that. I apologize. Intestate succession and will. I put them side by side because this intestate succession is what happens to your stuff if you don't have a will or otherwise a different estate plan. And they both end up going through probate. Okay, even if you have a will, if you've got real estate, that's what most people's source of wealth is in their upper years of real estate. If you have real estate, you have to go through probate court if you just have a will. Okay? And I'll talk to you about ways that we can avoid going through probate, because well, in Colorado, probate's not the most complicated process. A lot of people just want to avoid it because there's some fees, there's some time, there's some formalities, and we as Americans don't like formalities and fees and hindrances. We like to just be free. And so a lot of people will want to avoid probate. But these two, you're going to probate if that's all you have. Okay? You can pass property by way of trust. A trust will avoid probate. Okay? Typically, what people will do, you have irrevocable trust, you got revocable trust. Okay? And some people call revocable trust living trust. I don't like calling it that because it confuses living wills. So we'll just call it a revocable trust. Okay? Yeah, irrevocable. We got revocable. Okay. I'll hit irrevocable first because most of you guys won't have any interest in that. The irrevocable trust means you take all your stuff, or whatever stuff you want, you put it into an irrevocable trust, and it's irrevocable. You can't take it out. You can't control it. Okay? You're getting rid of control of it, and you can't take it out anymore. You have to have somebody else be the trustee. You can be the beneficiary of it, but you can't direct the use or control of that property. Somebody might say, you might put your house into an irrevocable trust, and your trustee might say, you know what, the market has gone crazy, it's gone up. I think you should sell it and put all of your money into something else. And you might say, well, I'm pretty comfortable in my house. They would say, yeah, let's find you another comfortable home. And that doesn't feel good. Most people don't end up doing irrevocable trust. There are reasons to do them. If you're thinking about estate tax liability, which most of us have no estate tax liability because the estate tax limit for an individual now is almost $12 million, and for a couple it's double that. So most of us don't have to worry about estate tax planning anymore. That expires at the end of 2025. We'll see what Congress does about that.
And these are probates.
These over here are probates.
Okay, okay, irrevocable and, okay, these two are probate.
Yeah. These are non-probate right here, okay? Trusts are non-probate. They're non-testate. Sorry. Non-testate. I'm going to put.
What does probate mean? This is court?
Yes, probate court. Probate court. Where the judge supervises the administration of your estate. Okay? And a lot of people just want to avoid it. There are ways to avoid it. Let me talk to you about some of those. First, we'll go to the trust. A lot of you guys have kids. One of my favorite lines, I don't know if you guys remember when Mitt Romney was running for president, one of my favorite lines that he said, he's a lawyer, he says, corporations are people too. Right? You guys want to have any more kids? That's fine. Let's make them corporate kids, right? You can trust are like corporations. They're an entity that doesn't, they're not really an entity, but they don't really live, they don't have a life, they don't live at any natural time, so they can exist forever. So if you want to pass things outside of probate, you can transfer your assets into a trust. Okay? Trust isn't an entity, it's a relationship. You say, hey, trustee, I want you to hold this property for the benefit of the beneficiaries. Okay? You can be the trustee and the beneficiary. But when you die, the trust still owns it and the new trustee takes over. I don't know if that makes sense. Transferred into a trust, the trust owns it, when you pass away, the trust still owns it. It doesn't have to go through probate. Okay, and then the trust can distribute it however you say. If you have minors that you want to give the property, you can say, all right, I'll give you some income for a little while, but I'm not going to give you this big chunk. Because we don't want to give young people a lot of money, because what do? They ruin their lives, right? They're just,
So co-trustees can make changes after stage 2 on it. When one passes, they can make changes on that trust.
well, trusts are one of those beautiful things where they can do almost anything we want them to do. Okay, so typically the grantors, the people who make the trust, usually it's a husband and wife, they say, we're going to make this, in my case, this Smith family trust. Me and my wife make this trust. If I die, maybe she wants to change some of the terms of it. She's one of the grantors. My wife can change some of the terms of the trust. Okay? Once she dies, nobody can make any changes. Except if we make it possible for that. But we do
The original writing of the trust.
That's right. The grantors have to give somebody else who's not a beneficiary or a trustee the power to change it, but only to make it consistent with what their original intentions were.
So they become executor. And both parties, both trustees are deceased, then an executor takes over.
No, there's some vocabulary with executors only exist over here, right?
Non-custody.
Probate.
So the executive one,
The executor is the person who administers your estate in probate. Now in Colorado, we don't use that term executor anymore. Everyone knows what you're talking about, but we don't use it. I don't know why, because it's a fun word. And I like the counter to that is executrix. Right? When it's a woman, it's an executrix. In Colorado, we use personal representative. Right? Personal representative of the estate. It's the same thing, it's a different name. So, but if you have a trust, typically what you do if you have a trust, you have a will. I'm gonna
now, the
go here.
personal representative is both the interstate and the will.
Ask your question again.
That's it. It goes to both the trust and the personal rep.
We've got a personal representative,
Oh,
and over here we've got a trustee. Okay? Usually, when you do a trust, you do a will, and in the will you leave everything to the trust. What we want you to do is, while you're alive, put everything in the trust. It makes things easy, because then you don't have to do probate. Then when you die, what does your estate own? It's nothing, right? We want you to have your estate own nothing. Or if it does own something, we want it all to pass outside of probate. And if it can't all pass outside of probate, well then we'll do probate. But we try to avoid probate because it just costs you money.
So you don't need a will if you have a trust.
I disagree. I think you need a will. The will leaves everything to the trust. The reason you need a will is because, let's say today you do a trust, right? And you say, I'm transferring all of my property to the trust. My house, my cars, I'm going to make the trust the beneficiary on all my payable and debt beneficiary accounts, my insurance policy, my 401k, all that stuff. Everything's going to the trust. Okay, but then you've got another 20 years, right? What happens over that next 20 years? What do you accumulate? Stuff. We as people just accumulate stuff, right? You'll probably sell your car that you have and buy a different car. You might move.
the car is included in stuff.
Stuff, yeah.
Even like things that have deeds and licenses.
Yep, that's all stuff. Even stuff that doesn't, okay? It's called, there's realty. Everyone knows what realty is. It's real property. It's land. It's dirt, right? And there's also something called personalty. It's kind of an uncomfortable word to say. Personalty. That's everything else. That's your clothes. That's your furniture. All your personal effects. Your pictures. You know, all the things you bought when you're on vacation, all that stuff, that's personal. And that all gets transferred. What we want to do is transfer that all to the trust. But we all know that you're going to acquire more. Right?
Okay, if you just have just a will, can you put stuff in it, like cars?
No,
You just have a will.
a will is effective at death.
What's that?
And not before. A will is effective at death. Okay?
Okay,
A trust is effective at execution.
that's good. Executed it.
No, execution and death are not the same thing.
But it's all trees.
The trust is effective as soon as you sign it. That's what I mean when I say sign. And a will is not effective until you die. Okay, you do a will today, what happens if you live another 10, 15, 20, 30 years? You're probably going to want to change your will, right? Because over that time, maybe one of your children passes away, maybe a spouse passes away, maybe you get remarried. Maybe you realize that your kids are all scoundrels and you want to leave everything to the church or the Red Cross. Right?
So if you change it, will, and you have people inheriting things under the will, can you change that and change the inheritors?
Absolutely. You can change your will anytime until you die, or you become incompetent. Okay? So this happens with a lot of people, is they start to show signs of dementia or Alzheimer's. And at the early stages of that, well, people have good days or good weeks, and bad days or bad weeks. And in the early stages, you still have time to change things. But once it's fully set in and you're not confident anymore, you can't change your state plan. Okay?
And who judges whether you're competent or incompetent?
That's a good question. And every time I do an estate plan, I ask the person a lot of questions to make sure they know who they are, where they are, who their kids are, who their spouse is, when they were born, all these things to make sure they're competent. Because and I record it for posterity's sake, actually for court's sake. Because if one of the kids who was in the original will, this is where I always end up stepping in. You have one of the kids who's in the original will, then this estranged child moves back into the parent's life, and they start helping them a lot out at the end of their life. The parent changes the will, disinherits this kid, leaves everything to this kid. Well, this kid is going to say, my mom was crazy when she changed the will, right? And you're going to end up in court. And so who decides if you're competent? Ultimately, if there's a challenge about competency, it's going to be a judge. Yes, ma'am.
So if while you're competent, you assign a person to make all the decisions for you, when you become incompetent, can they do any of this?
That's a good question. And that brings me to another area that we do need to talk about, which is powers of attorney. Just think all that POA. Typically, when you do a power of attorney, you don't give that person the authority to alter your estate plan.
You don't need it. If you give somebody another will, you give the power of attorney, then you can't alter.
They typically can't alter the will.
I mean, I can't.
If you're not competent, you can't. If you are competent, you
If
can.
I'm confident, I can still change my will.
Yeah, if you give somebody the power of attorney, that person has a fiduciary obligation to act in your benefit. They can't do anything that's against what you want, right? So they might have the power to do something, technically speaking. But like, let's say you say, I want to live in my house, and they say, well, I'm going to sell your house. I've got your power of attorney, and you're confident. Well, if they try to do it, they violated their fiduciary
Already
duties.
signed over everything.
You shouldn't be signing anything over.
Well, it's out.
Yeah, it does happen. But if you signed over, if you have given somebody, when you say signed over, I'm assuming you mean
I
giving
gave
somebody.
I gave somebody my property, my estate to take care of me and they won't.
Yeah, if you've given somebody your property, then you've given it away. If you have given somebody your property with the agreement that they are going to use it to take care of you, that is a very informal version.
Okay, would that be until you die?
That's a very informal version of a trust. That's called a constructive trust, and that ends up in court. And you don't want to do that because it's very expensive, and a lot of times things don't get resolved quickly. But the best way to do it, if you want somebody to take care of you, you can use powers of attorney. You can use trust arrangements, right? And it's cheaper, and you create the rules for the game that are best.
Okay, so if you give away your property until you die, then what does that mean?
Then it means you gave away your property. Yeah, and you don't want to do that. Like a lot of people will make their child a co-owner of their house, right? So they've got their house, they own it, and they think, you know what, I want this child to get it, I'm just going to make them a joint tenant on this house. So I die, and they get it. I don't recommend that. I think it's a bad idea. Why is that? Well, because now they own it, right? They can sell their half if they want to. They can make it, instead of a joint tenancy, a co-tenancy, and sell their half to somebody else, and now you've got a roommate, which you never do, right? Or what if that person declares bankruptcy? Now all of a sudden your assets pulled into bankruptcy. What if that person has creditors and they attach your house? You have a lot of bad things if you add somebody who's an owner to an asset. Bank accounts, vehicles, real estate. One thing you want to do, if you make them an owner on real estate, when you die, their tax basis in that real estate is zero, right? So if they sell it, say it's a $250,000 house, and they sell it, they have to pay capital gains tax on $250,000. If they inherit it from you, their basis is the value at the time of your death. $250,000 house, you die, it's worth $250,000. They get it at $250,000. They sell it at that amount, and they pay zero in capital gains tax. You just save them $50,000 by not putting them on the value of putting them on the title of your house.
What about a beneficiary deed?
And so that's a beneficiary deed is another one of those things that is you get assets to pass outside of probate. In Colorado, made beneficiary deeds statutory a few years ago. The beneficiary deeds were created in Texas in the 60s. They were called a ladybird deed. But now we call them beneficiary deeds. And it's like a will. It's a testamentary document. It doesn't go into effect until you die. Okay, so you can do a beneficiary deed today, and in 3 years, when you decide you want to disinherit that person, you can revoke the beneficiary deed and do a different one, or just revoke it. But if you do a beneficiary deed that passes outside of probate, it's a non-probate transfer, so it doesn't go through court, it just automatically transfers at your death. So they get the value at the time of your death, and they didn't have to go through probate. That's one of those things that allows things to pass.
Yeah, what if there's a mortgage attached to it?
Yeah, a lot of people have questions about, like, what debt? What of my parents' debt am I going to have to pay? The mortgages are drafted in a way that they attach to the property. They're secured by property. They're not secured by the estate. And so, if there's a mortgage attached to it, typically what happens is, as long as you keep making that payment, the mortgage company doesn't care. If you decide to sell it, it's just like on your house. If you sell it and it's got a mortgage, the mortgage company gets paid back, and you get the equity.
So if you use a beneficiary deed and it passes to that person at your death,
Yes.
and they sell it, do they have to pay capital gains?
No, so that's one of the benefits of the beneficiary deed. Colorado's made it so easy for us to pass things outside of probate that a lot of times, like I say, everybody needs a will. but it's not sufficient. And you can do other things other than a will. For example, beneficiary deeds. Colorado has a transfer of title on death form that you can get for the DMV for your car. Okay, you want your car to go to a certain kid, just go fill out this form and have it notarized. And when you die, the car transfers, and you don't need to do probate to get that car transferred. It's a non-probate transfer. Other ways that you can do non-probate transfers, I'm going to tell you all about these because this is the best way to get things passed on. Non-probate transfers of trust. At the bank, you can do transfer on death, right? Or payable on death beneficiaries. You may come to the bank, tell them you want them to have your account go to a certain person on your death, and that becomes a contractual arrangement where as soon as you die, it goes to this person. Okay? It goes outside of probate. That person doesn't have any control over the asset while you're alive, but it goes to them automatically on death.
Even though they're power of attorney.
That's a different story. If they're power of attorney, then they've got power over whatever you give them power over. And that's one of the reasons why you should come talk to an attorney, because they can say, in your situation, with these kids or this spouse and these assets, then these are the powers that you want to give power
Okay,
to.
but what if it's too late? You already have a power of attorney.
You can revoke a power of attorney. Powers of attorney are effective while you're alive, and so long as you allow them to be effective. You can revoke them at any time, and they're automatically revoked at death. Power of attorney only gives your attorney in fact, the agent, the power to do what you can do. And if you are dead, you can't do anything. Okay? So power of attorney ends when you die. Okay?
Yes, what about naming beneficiaries to your bank accounts?
Yes.
Can you name how many does that work without a will?
Absolutely. And that's one of the things that you should do. You should name a beneficiary in a bank account. A lot of times what we do is we'll name a child or a spouse as a beneficiary. I know on my life insurance policy I have, because you can do on life insurance policies, bank accounts, retirement accounts, you do beneficiary deeds. But I have my wife as my 100% beneficiary in all my accounts on my life insurance. But if she's not around, it's one of my kids, right? You can do these contingencies. Even on beneficiary deeds, you can do a contingency. What if that child dies before you? What if they die? This is where it's going. Okay.
We also have a common law marriage, and we don't have 10 years. Then like my kids come in and take everything, so who would get it?
Let me clarify the question. You asked if you had a common law marriage and do you have any kids with that spouse?
No kids, that's
Okay. All right, so common law marriage, you can take off those first two words, right? It's a marriage. It's a marriage just the same as if you went down to the court and got married by a judge or from the church. It's a marriage. And the state treats a common law marriage the same as any other marriage. If you want out, you gotta get divorced. There's no such thing as common law divorce. Okay?
At what point does it become a marriage, I guess? If it's just like a one night stand, or you automatically.
You're going too far.
That's a good question. A lot of people have this misunderstanding. They think that common law marriage is, if I lived with this person for 7 years, then we're common law marriage. I have no idea where that comes from. It's not in the statutes. It's not in common law. But everyone has that idea. The way it is in Colorado is, if you consider yourself to be married, if you guys consider yourself to be married, and you hold yourself out to the world as being married, well, you're married. It's that easy. Right?
So you're not required like to file taxes together, for example, to concrete that marriage?
No, and there are even cases where people have filed taxes jointly
Okay.
and have been determined to not be common law married.
Oh, wow.
So,
What happens is like whatever go back taxes, can they hold the other down before?
for
Just take turns there, I hope I don't do this so much. And
if you file taxes jointly with somebody, odds are that they're going to be liable for
if you
it.
don't, they can't come back.
That's right.
Thank you, sir.
Yeah, and if you're married, common law or otherwise, and you have kids from prior marriage or other situation, if you do intestate succession, the state is going to say this is how you're splitting things up. If you do a will and do testate succession, you get to decide how things go to a certain extent. Hopefully that answers that question. Okay. I want to talk to you guys about talk about trust, which is I think a good way to pass things outside of probate. We've talked about other non-probate transfers of assets, beneficiary designations on life insurance, retirement accounts, bank accounts, those sorts of things. Beneficiary deeds, transfer on death titles on your vehicles. And I always like to, well, let me say first off, those don't benefit you guys at all,
Effective.
right?
Effective what?
Oh, effective. This is effective at execution. This is effective at.
Effective execution. Effective.
So these things like the trust and all these designations of how you distribute property doesn't benefit you guys, right? Where are you going to be when your properties get distributed? You're in the ground, right? You can be dead and they don't help you at all.
Effective execution.
Yeah.
That goes under will. Trust and will.
This is under trust.
Oh, that's trust.
Effective death is under will. The things that will benefit you guys in your life are these powers of attorney. Okay? Powers of attorney and living wills, advanced directives. That's what we call these things. Advanced directives. Power of attorney, Colorado, again, statute. The statutes have what's called a statutory power of attorney. The legislature said, I'm sick of everybody not accepting powers of attorney. It used to be you go to your attorney, you'd fill out a power of attorney, and you'd take it somewhere and then say, we're not going to accept that. That's not the form we like it to be in.
Do they have to be in this state to be a power of attorney? Or do they be in another state?
They can be in another state. They can be another. But the state said, this is happening too frequently where people are not accepting the powers of attorney that people have created. And so they said, okay, if you do it in this form, everyone has to accept it. Okay? That only applies to people in Colorado. So it's called statutory form power of attorney. And in that power of attorney, you can select general powers. This person generally has the power to deal with my real estate, with my personal property, with my vehicles, with my investments, all that stuff. And then after that, you've got specific powers, which are very dangerous to deal with. We usually only deal with one or two because they're very specific to each person's situation. But you need to do a power of attorney. That statutory power of attorney is durable. Okay? What that means is, if you become incompetent at any point, the power of attorney is still effective. And really, that's when you want it to be effective. You want your power of attorney to be effective when you can't make decisions for yourself, because you need somebody else to do it. What happens if you don't have a power of attorney to totally effective?
And that's also a beneficiary that's on your children.
Absolutely, yeah. You can, a lot of times when you've got that one big kid, you make them the trustee, or you make them the personal representative, and you also make them your agent. And what I do a lot of times is for spouses, we make the power of attorney effective immediately. Okay? Because, well, we trust them enough that we marry them. We have kids with them, we have a bunch of property with them. We should trust them enough to make decisions. But a lot of times for kids, I won't make that power of attorney effective until you become incompetent, right? Because you want to make your own decisions until you can't make your own decisions. And if you can't make them, you want somebody to be able to make them. But maybe you don't want that person to make those decisions for you before that. We call that a springing power of attorney. Okay? We take some power of attorney, we want them to be durable, and you want them to be effective either immediately or springing. Springing power of attorney springs into effect at a certain point in the future. We usually draft that in saying, if you're determined to be incompetent by two positions, then the power of attorney becomes effective. Okay.
So, you have a financial power of attorney. Okay. Financial. You also want a medical. Medical durable power of attorney. Because if you have a power of attorney, like the Colorado Forms statutory power of attorney, that person can make decisions regarding financial affairs.
Now the medical has changed, you can have assisted suicide at death.
Yes, and that's different than the power of attorney.
The power of attorney doesn't have anything with that?
No. The power of attorney gives a person authority to make decisions for you, but it's not a declaration of assisted suicide. That's a different document. The medical durable power of attorney is effective when it lasts even if you're incompetent. It gives somebody the authority to make medical decisions for you, and it gives them access to your health information. Everybody knows about HIPAA, and you want someone to be able to make decisions for you, but you also want that person to have access to the information that they can make their decisions. So that's all what would be included in the medical durable power of attorney. Yeah.
Is that one that the doctor has you fill out when you go to the doctor, is that the same thing?
Well, it may be, I'm not sure. Every hospital has a different form. Some doctors'
It's
offices
not
do it.
the same, it's not,
It's not.
Yeah, usually what you're filling out
an emergency.
would be like a do not resuscitate type thing, like what do I want to have happen? Like that's called a living will. A living will, I'll add that there.
That's when you look at medical.
Yeah.
And that doesn't have anything to do with the assisted suicide.
That's right, it doesn't have anything to do with that.
Now, what do I have to do?
Yeah, living will is if you are declared to be, if you have a terminal condition, or if you're in a vegetative state, or persistent vegetative state, what do you want to have happen with artificial nutrition and hydration? Right? Or do you want to be on a feeding tube? If you're brain dead, how long do you want to be on a feeding tube? Right?
So your kids' power of attorney can say, live like my waste was if I'm 20 days. They can make that decision.
Well, if you say they can't, they can. Or if you say that they can, then they can. So a lot of times in the medical power of attorney, it'll give you authority to do all of these things. But in your living will, you might say, I want the court to be told, right? I don't want, if I'm brain dead, I don't want to be on artificial nutrition and hydration. But you can also say, I'm going to give my medical agent the authority to make that call. They can override my living will. So you can give that authority. Or you can say, I don't want them to have that authority. Because for a lot of people, that's a big, heavy stress. You know, how do I go in and say, okay, my mom, who I love dearly, is on life support, and she's laying there, and she has given me the authority to pull the plug or not. I'd rather her just.
That's your power of attorney then.
Yeah.
What you just said? No. A power of attorney, that can do this.
Medical. And that's only if you give them the authority in your living will. Because you can say, I want my wishes to trump their wishes, or you can say, I want their wishes to trump my wishes.
Can you put a time limit, like if there is no improvement within 3 days, something like that?
Yeah, you can say, because a lot of times people know, look, I'm a vegetable, I'm going to be on, like, I've been in a coma for a while, right? I've got this traumatic brain injury, in a coma. The doctors all say I'm not going to recover. I'm never going to regain consciousness. And you might say, well, hold the plug, don't give me any food. Or you might say, you know what? I've got kids who are scattered all over the country. I want to give them a chance to come see me and say goodbye while I'm still alive. And you might want to say, give them 3 days, give them 7, give them 10. You might have some hope where you might recover after 3 months. You could say after 90 days. Most people don't say that. You can't do a specific time. Yeah. we have kind of, you guys have pushed through this really quickly on your questions. Does anybody have any lingering? Good.
If you write a handwritten will yourself, does it have to be filed someplace?
No, okay, so wills don't have to be filed anywhere. The only will that's effective is the original will. Copies of wills are not effective. If all you have is a copy, you're gonna be in court, someone's gonna be in court trying to get the court to adopt it. A handwritten will is called a holographic will. You can write it. It doesn't have to be notarized. It doesn't have to be witnessed. As long as it's written in your handwriting and signed by you. It doesn't have to be recorded anywhere. I don't necessarily recommend doing that, but if you do it, make sure you put it in a safe place, like a safe or a safety deposit box or something like that. You had a question, Eric?
So, kind of what I'm getting is a safe to assume that, yes, we need a will. Good idea, trust will correspond with that. And then as far as, like power of attorney having the living will, medical, financial power of attorney, those are all separate documents, correct? Or can you incorporate all that in one document?
Well, we can, no, we do it all. It's kind of like when you buy a house, you know, when you have that, the notary there, and they're flip, sign, yeah. So you can do your trust, you sign that separately, then you do your will, you sign that separately. You do your financial power of attorney, you sign that separately, same with medical power of attorney, your living will. All those things you sign separately, but you put them together. We put them in a binder for people that are tabbed so that if they have thoughts, they can look in it, they can make notes, they can revise things as needed.
Okay.
I'm sorry, I'm going to ask further.
Is a trust that's created in another state recognized in the state of Colorado?
So when you pass away, the law that applies is the law in the jurisdiction where you pass away. And so if you, let's say you live in California, we're going to call it the Republic. I think it says that on there.
It was there, just so you know.
It was what?
It was Arizona.
Oh, okay. Well, Arizona's similar because Arizona is a common law state. Or sorry, yeah, it's a common law state. Community property state,
Right.
just like California. And the way you aggregate property in community property states is different than in non-community property states.
Okay.
Colorado is not a community property state. And so if you take an Arizona trust, you need to make sure that all of the terms of that trust comply with Colorado law, and you will need to register it when the trustee starts back. If it's your own revocable trust, and you're the grantor and the trustee and the beneficiary, you don't need to worry about that later in life.
Until one of us.
That's cool. Yeah.
How about personal representative from another state for a trust? Is that the requirement that they have to be in Colorado?
No, and again, personal representatives are under the will,
Same for the trust as well.
and the trustee under the trust, they don't have to live in Colorado. They can be anywhere
Okay.
in the world, really.
Perfect. Thank you.
I have two questions that I get on my accounts. One is TOD.
Yeah.
I don't know what that means.
Transfer on debt.
Okay, and the other is life estate.
Oh, life estate. Yeah, we haven't talked about life estates.
Okay.
Let me make
Now,
a
I
note.
can't have things that has life estates on it.
Let me make a note of that, and I'll come back to that in a moment, okay? And you had a question?
Yes, what if you want certain paintings or pieces of furniture to go to different people who like nieces or nephews?
Yeah.
If you just put it on the back of a painting or on a piece of furniture, does that work?
It's better. It's better to create a list. Usually, when I do a will for somebody, I'll give them a document also that has a specific. Those are called specific gifts.
Oh.
Okay. There are specific gifts and general gifts. There are specific devices and general devices. And always, what goes first is the specific device. Okay. So if you have specific gifts, we'll list them. I'll give you a sheet. This piece of property, I want to go to this person. This is their relationship. Right. That's a good way to do it, because then it's with all your estate planning documents. Some people will want to put stickers on things. And that's a bad idea, because stickers can come off and get on something else. Yeah, so I don't recommend that, but I do recommend making a list that you then sign. Right? And
It will be part of your will.
yes, part of your will or in your trust. And specific gifts go first. I'm going to give you an example of that. Okay? Let's say you say, I have these 10 charities. I want each charity to give $10,000 cash when I die. And I want the rest of my property to go to my kids. Well, what happens is, when you die, you got $100,000. Those 10 charities each get $10,000, and your kids get nothing. Right? Specific devises go first before general devices, or their health residuary processes. So there's another question. Okay.
What happens if one of your parents made you the executor of their will? You become estranged from them. They never change their will. What happens when I'm obligated to still be the executor?
Oh, yeah, the person representative / your case executrix would not have any obligation to serve in that capacity. You can, 13th Amendment outlawed slavery, and you do not have to do you're not obligated, you're not compelled to do it. You can just say, I'm not going to do it that way. And usually when we do a will or a trust, we have successors. In the case this person can't or won't, then this person will or can't.
And if there's no successors, who decides that in court?
Yeah.
Who's going to step up and handle it?
So it will either be the courts or it will be the beneficiaries. Because the beneficiaries, let's say it's 5 people, and they all say, you know what, we don't want, most of us don't want to do anything with this, but this one person's there and they can, we all agree they can do it. Then they can just say, hey, court, assign me to do it, and no one objects, and they can do it. Or allow them to do that.
Is there anything special once you get the trust that needs to be done to legalize that trust? Just the signatures,
No, yes.
filings?
You don't have to file it anywhere. One of the benefits of trusts are they're private. Okay? Probate that's a public process. That goes into the court. Anyone can go into the court and pull those records and see all the properties you own and who went to. If you trust, they're private. You don't have to register them anywhere. You have to register the contents of the trust. You do, if it's a trust that's going to be administered over years, you do have to register with the state, but typically not.
And how do you mean by register? File it?
Yeah,
Record it?
you don't have to, no, because you want that to be private. What you do is file something to the state stating that this is a trust. The Secretary of State can say this is a trust, it's in existence, and we're functioning. And you just give notice, that's it. We go here and then.
Beneficiary deed,
Yeah.
Does that have to go through a lawyer, or is there a form that you can just fill out?
There is a form. There's a statutory, because they created this by statute 2 years ago. It said if you do it in this general format, it's going to be okay. And so that's what you fill out the form. You can go through a lawyer. Of course, I recommend you go through a lawyer. You don't have to though. You can fill it out. Okay? But what you have to do with the beneficiary deed is it has to be recorded. So you can't just do a beneficiary deed and stick it in your safe. It's not effective. You have to do it, you record it with the county. And then if you decide you want to revoke it, you're going to revoke it, record that with the county. The beneficiary deeds are good and powerful, but there are some formalities that you have to do.
Is there also the appeal payment on death or divide the same? Can you revoke that?
Typically, you can't revoke a life estate. You can't revoke a life estate. But you can revoke transfer on debt, the TOD account. You can change the person that you have listed. They will never be transferred on that.
So you can change a POD.
TOD. Yes, TOD or POD, yes.
Is there a best practice for storage of all of these documents and communication to, who's managing all of this?
That's a great question. What I recommend is, so when I do an estate plan, I have somebody tell me, where are you going to keep your original documents? I give them I give them the originals and they seal them envelope. And then I give them copies in a binder. I say, if you want somebody to know what's in your estate plan, make a copy and give it to them. Okay? If it's your successor trustee, or the person who's going to be your representative, or the person who's going to be your agent, give them the documents that you want them to have, copies of the documents. Okay? And then when I do an estate plan, you tell me, this is where I intend to keep my documents. And a lot of times it's in my house, in my safe, that's in this place, and the key is here, or here's the combination to the lock. And I keep those records at my law firm. And nobody sees those until they come to me and say, hey, so-and-so passed away, here's the proof of their death, and I'm so-and-so, I can look at the estate plan and say, okay, yeah, you're the personal representative, this is where their estate plan documents are. Or you can just tell them. You just tell them, this is where it is. So a safe, a fireproof, waterproof safe in your home is a good place. A safe deposit box at a bank. You guys have safe deposit box?
We do.
Good place to do it. Keep it here, it's gonna be safe, you know where it'll be.
Okay, so how do you change the pay on debt account?
They typically forms, so payable on debt accounts are with institutions like credit unions, insurance companies. You go to the institution that holds the account and you ask them for the form, they give it to you, you fill it out.
Okay, and so because you don't file wills anywhere, if you have a will but you want to do a new will, you can just rip it up.
That's right. Yeah, okay, so the reason I give someone a will in a sealed envelope is because I don't want you to do anything to it. As soon as you write on it, now there's a big question mark about whether it's effective or not. Did she intend to change it when she wrote on it? We don't know, and now it might go to court. So if you want to revoke a will, you can draw a line through it, tear it up, throw it in a fire. Any of those things are acts of revocation. Okay? Yeah, you don't record a will until someone's passed away, then you have to file a report.
So just the rough idea, like if I were to come to you or anybody else and just say I want to get these things put in place, like ballpark, is it dependent on fee as far as their like a general fee to just put something basic together, or is it depending on like your state, like what you're talking about?
Yeah, so the cost of it does not depend on the value of an estate at all. It depends on the complexity of the plan and the documents that are being prepared. If we're doing a will, I don't remember how much we charge. I think it's around $750 for just a will. Most people, I don't recommend just a will, because wills, they don't do anything for you, but all of this stuff does. This is the stuff that I think is most important, right? Except for, I've got 4 little kids at home, so of course, I want to do a will and trust. But it's not going to benefit me. For me, I want to do all of these. And if I'm going to do all of those, they cost a lot extra.
Okay, life estates.
Oh yeah, let me get back to life estates. You have a specific question about life estate?
This is, I haven't come in the mail. Refunds the money.
No, I don't think that's a life estate. So life estates are typically,
They won't cash.
no. So life estates are typically an interest in property that you give somebody that's for the rest of their life. Okay? So this comes up a lot of times in Medicaid planning, which I know just enough about to know when I should refer somebody to an expert in Medicaid planning. I'm not going to talk to you guys about Medicaid plans today.
Yes.
No. But it is a way to reduce the value of your estate so that you can qualify for Medicaid by transferring somebody else the property, but reserving to yourself a life estate.
So you have to transfer your property for Medicaid.
That's, I'm not gonna get into Medicaid because that is a landmine-filled area. So I'm not looking at it.
I believe you said something about filing the will.
Yeah,
If you don't have real estate, you don't have to file, right?
yeah, and you can make that determination. You don't have to worry about recording the will until after the person's passed away. If they've passed away and they've got a will and it says, I'm leaving everything to my wife, and their wife is alive, and they don't have anything, their real estate is all owned jointly, not as co-tenants, but as joint tenants, you don't need to file a will because it automatically passed, right? Things, ways that you can pass property outside of probate. Maybe I should write these down. These are all very good things. Non-probate transfers. We're going to do joint tenancy. You can own joint bank accounts as joint tenants, right? You can own real estate as joint tenants. You can own vehicles as joint tenants. You can own any property as joint tenants. Okay? DOE accounts and TOD, beneficiary deeds, beneficiary designations. Those are all ways that you can transfer property to that without going through probate.
Two people can sign a checking account balances. So,
It depends on how you open the account outside.
Okay, so
Because you can have somebody be an authorized signature on your account. They're not an owner, but they're authorized to sign on it, right? Just like you're granting, essentially what you're doing is granting to them a very limited scope power of attorney regarding that bank account.
well, my wife and I can sign on a checking account, is that? Because joint owners.
Not necessarily.
Oh, so,
No, you'd have to look at how you opened the account. Did you open the account for you and make your wife an authorized signatory on it? Or did you open it as a joint account? You just need to check and see. Okay.
What is their name and hers?
Yeah.
So John and Elaine.
Yeah,
You have it that way, then you're joint.
check on the names on the account if
So
it's,
see
if
how
it's
it's wrote out, same thing on the cards.
Yeah.
You and her. That makes both of them three.
okay,
So I have a question. Bank account. Something happens. You have given one of your debit cards to your account to a kid. And I said, if I pass away, you go get as much money out of there as you can. No problem. Have an ATM machine.
Like each attorney on this, that depends. If your authority that you grant to somebody to use your property really ends at the end of your life. Okay? If that person that you gave a card to is the payable on death beneficiary, that's no problem. But what if somebody else is the payable on death beneficiary? Okay? You have a card to one person, beneficiary's over here, this person goes and takes out all the money, what did they do? They just stole a bunch of money from this person. Is that your death? It's not your money anymore. It's now this person's money. So it depends. Okay.
so if you have someone sign your checking account with you or you make the arrangements, that means they inherit your savings and everything.
Not necessarily.
Okay, how do you find out? You look at the will?
No, you would need to contact the bank and have them look at your documents to see, are they an authorized signer? Are they a co-owner?
No, they're authorized to sign my checking account as far as I know.
Yeah, that doesn't necessarily make them an owner of the account. It doesn't even necessarily make them the beneficiary of the account.
But if they are a co-owner, on my death,
They still own it.
yeah, it's all theirs.
Right.
Then if they're, like she just said, they then have access to your savings account.
That's right. The preferred, during your life, because the preferred way, if they're a co-owner, they own it even after you die. If they're a child that you want to have this money after you die, the preferred way to do it, in my mind, is do not make them a co-owner. Make them a beneficiary. So then they have no control over your life, but they get it when you die. But it's not their asset yet.
Those are trust funds.
That way they can't break it.
Certain thresholds.
So that way they can't break it before you do it.
Yeah.
So you have
and
them
it's
on
not just trust levels. Hold on a second. It's not just trust levels because it could be creditor levels, right? Because what if that person has creditors and now their name is on an account, or if they declare bankruptcy, then that all gets pulled in. It's usually better to make them, if you want them to have access to it, make them a signer and make them a beneficiary, but don't make them an owner.
That's not appropriate.
That's not, yeah, that's not probate transfer. And it's a non-probate transfer if it's a beneficiary designation.
So when you're a beneficiary at death, they own your account.
That's right. It's like the life insurance policy. The beneficiaries don't get it until you die. It's the same on beneficiary deeds, beneficiary designations, DOD accounts, DOD accounts.
Speaking of life insurance, is this a bad idea to make your, not your beneficiary, but your executor get your life insurance and then have him disperse it the way you want him to?
So I appreciate the question. I'm going to rephrase it a little bit, okay? Because you use the term first representative or executor, right? You can't really leave something to an executor as an executor. What you can do is leave it to a trustee, but you can make your trust the beneficiary of your life insurance. And then it gets paid to the trust and then dispersed according to the terms of the trust. Okay?
If you take that trust, say, and you don't register it, how can they prove that it's legit? Say like this, and go against this.
If they want to go against your trust,
Yeah. Can they come in and say, hey, you didn't write that?
oh sure, they can challenge that. And people do that all the time in court.
Consider the register, like you said, or file it.
No, you don't need to file it before you pass away. What you should do though is make sure that the people who you want to have copies. And when I execute a trust with somebody, I record their conversation with me ahead of time. So they say, this is what I want to have happen. And then we also include what's called a poison pill provision. The poison pill provision is, if somebody tries to challenge that trust or that will, then they are disinherited. Okay? Thanks for that. Okay, so if they want to mess with you, you're gonna mess with that, right? You can disinherit that.
Okay, let's say you have your estate all going to one person, which I think you know until now.
Yes.
If they die, will this all go to their children?
It depends on how you have the plan set up. Okay, so typically, when we do a will, we can say we got 3 kids. So in your case, you have 1 child, right? I want everything to go to this 1 child. And if they predecease me, if they die before I die, then I want it to go to their kids.
You say that, but what happens if you don't?
Well, then that's what they say. If you don't have a will,
Oh, okay.
if you don't have a will and it passes according to the intestate succession, that's what happens. Okay.
So because I have the paper signed by a will, everything will go to them and then their children.
Typically, yeah. I would have to go to the will to see exactly what it says. Any other questions?
Just real quick, we talked, we mentioned advanced directives, is that part of, is that what those are?
These are advanced directives.
Okay.
Medical power of attorney, the living will. There's something else that we do is it's called the disposition of last remains. What do you want to have happen to what's left of you. Do you want to be, have a funeral? Do you want to be cremated? Do you want to be buried in somewhere in particular? Do you want your ashes scattered in the wind? I don't know if you guys know this, but you can have your ashes made into gemstones now. You know that.
All of a sudden, your wishes are illegal.
Well, then it's up to whoever has to owns your remains. Yeah, any disposition of last remains, you can decide what you want to have happen. I have a little sister who passed away when she was young, and she was buried in Colorado Springs. And my parents bought 2 burial plots next to her, and they've been there for 40 years or so, and then they moved. When they moved, I said, well, shoot, we don't want, I'm over here and she's over here. So what they did is they sold their burial plots, had her casket and tomb, moved everything over to where we are, bought some more burial plots, so you can say, I want to be buried here next to this person. Or I want to be cremated and put in my wife's casket when she passes away, or whatever we want to do. We can do all sorts of things.
But we don't have to body time.
Yeah, so you can, so that's a good point. You can also say, what do you want to have happen with your body? Do you want it to be donated to science? Do you want your organs to be used for transplantation purposes? Do you want to donate them for science? Do you want to donate them for transplanting into anybody? Do you want to donate them to all your family members if they need them? You can decide all of these things.
What did you say all this falls under? What is the term?
Advanced directives.
Oh.
Yeah.
Was there another disposition of
Disposition of last remains? Yeah, okay. Yeah.
How much communication should you pass along? I mean, as a financial institution, sometimes we have, payable on death accounts, and it can be hard to find those people that are the beneficiaries.
Yeah, that's a good point. When I do an estate plan, I get all of the names, addresses, phone numbers, email addresses, I get all the contact information for all the beneficiaries. I know that in the last 27 years, I've moved probably 15 to 20 times. My address has changed a lot. I was in college, and so my email address is still the same. My phone number has been the same for 23 years. Those are good bits of information to give somebody who needs to contact people. And if you can't find them, well, sometimes we have to hire private investigators to track people down. Because if the property is supposed to go to that person, then we want to make sure that it gets to that person. If you can't find the person, well, what happens? You got some money, whether it's $50, $50,000, $500, you got something, right? And it has to go to this beneficiary. You can't find it. What happens is it ends up going to the Secretary of State. And I don't know if you know this, but you can go to the Colorado Secretary of State website and do an unclaimed property search and find out, are you owing some money? Did you have a deposit somewhere that you forgot about and they had to return it and find you so that you're in the Secretary of State? The Secretary of State has to hold it, and if nobody comes to it for a certain amount of time, well, guess who gives it? The people of the state of Colorado. Yeah.
It's called the Great Colorado Paper.
That's right. Yeah, so you can go and search for them. And it's free, just go. Yeah. Did you have a question?
These necessarily newspapers, it just means people in the state have money.
Oh, yeah.
I don't know if they listen here. Apparently on the website.
Yeah, on the website for sure. Yeah, that's it.
My father will, because he's actually shooting spread archer. And after he died, his widow was getting ready to do that, and someone, I thought, told her this is illegal. And so she ended up having this actually stored in the house lawn in Los Angeles. So the whole story You don't always get what you know.
That's right. That's right. Especially when it comes to that sort of thing. What you're relying on in that instance is the willingness and ability of the people who have care and control over your things to do what's best. Sometimes it doesn't always work out. Yeah. I didn't say that, but
One other.
Yeah.
My sister died, and her will was she wanted half of her actually spread out Mount something or other in Vermont, and the other half she wanted buried alongside the mother. So her son built a nice little box with a divider, and all the ashes were in there. So they all went to this mountaintop, and the other spoon, and they all found the rest of the spoon of half of the box. And then later, the rest of the box was buried in the cemetery.
Yeah, your wishes can become complicated. I want to recap. Feels like the questions are winding down. So, it's powers of attorney are what benefits you guys during life. Powers of attorney, advance directives, living will, which are the things that benefit you during your life. Wills and trusts, they benefit your heirs, and you will pass. I feel like everyone wants to pass things outside of probate. There are some good and powerful ways to pass most, if not all, of your property outside of probate. I did neglect to mention one thing, and that is a small estate affidavit. Let's say you transferred your bank accounts to a beneficiary designation, life insurance to a beneficiary, remainder of your retirement accounts, beneficiary designations, real estate, beneficiary deeds, or joint tenancy. Joint tenancy only works for the first person to die by the will. The second person needs to have something else in place. You passed on most of your property outside of probate. You didn't pass your bed, your furniture, pots and pans, your pictures, all your mementos. You haven't dealt with any of that. You can't deal with any of that stuff outside of probate. Okay? And what you can do, if that stuff is worth less than, I think this year it's $65,000, maybe $70,000. If it's worth less than that, you can do what's called a small estate affidavit, where you can say, hey, court, this is all that's left. It's worth less than this. We're just going to divide it in this area things. Just a little bit of property and stuff. Good stuff.
Which is that will, did you say?
It goes however you determine in your will, or through intestate succession. Okay, so if your husband survives and he gets it all, the last one to die, if there's no will, it just gets divided between your heirs, whether that's your kids, or grandkids, whoever is the next level. Okay.
You said advanced directives are, they benefit us during life.
Yeah.
Trust benefit us when?
You don't benefit you until after that. So they benefit your benefits, your beneficiaries. Wills and trusts benefit your beneficiaries, not you.
No. I get you to explain about the small stuff.
Small estate
A
affidavit.
small estate, small estate affidavit.
Yeah, small estate affidavit is for estates that don't have much property. If there is a will, it does not necessarily have to go through probate if the value of it, if the net value of it is less than, I think it's $65,000. Then you just fill out a small estate affidavit and say it's worth less than this, or you're transferring. And you can even do that with title property, like vehicles. But you can't, cars. But you can't do it with real estate. Okay? Even if the real estate is only worth $10,000, you can't transfer real estate with a small estate affidavit. It has to go through probate.
And the small estate affidavit would be the piece that's proven rented, essentially. Is that it?
Or just have personal property to you guys. And not a high dollar value. I've had some clients who have art collections or wine collections or firearm collections that are in the hundreds of thousands of dollars. that doesn't get to pass through a small state.
Register.
Oh, yes.
Be smart and check the outside.
All right, so firearms are one of those things that a lot of people have. You gotta deal with it, and you can't. You don't want to transfer firearms via a trust because if you transfer them to the trustee has to get a background check for all of those firearms, right? We don't have a firearm registry in Colorado. We're in a registry in Colorado. But if you are transferring a firearm, ownership of it, that person has to get a background check. Right? So my suggestion to people with firearms is get rid of them before you die. Okay, if you have a gun that you want to kill your son or your daughter or whoever, transfer, because you can intra-familial transfers without doing the background check formalities. So just start owning, what you have, give them away, and then if they're there, my experience is a lot of times they're there when you die, but when people go to take inventory of your state, somehow they're not there anymore. I'm not suggesting that, but that's a lot of times what happens.
You forget that somebody was engaged with but these people develop.
Yeah, I can't.
I have a possession of it, I can't give it to you.
You can't.
Well, I would,
Yeah. Yeah, so you gotta hold on to it. Or sell it and give them money, but if it's your brother's property, then you're sold it for him. So firearms can be complicated. That's why I always say, try to get rid of it before you pass away. That's the easier way to do it. That's right. Give it to somebody who doesn't let them, you can borrow it, right? You can borrow it. Yes, ma'am.
So I need some advice over a few of these topics, and so when I call your officer, I just ask for a consultation, initial consultation. Is that how that works?
Yeah, because everybody that we take into our office, we have to do a conflict check to make sure that we have no conflicts, that we can actually talk to you. So if you call into the office, they will do a conflict check. They'll ask you for certain information. It takes a little bit of time, but then they'll make sure that we're ethically talking.
Okay, the conflict, would that be with another attorney or would that be with your power of attorney?
No, if there was a conflict, it would be because maybe I represented somebody who was against you on that same matter.
Okay.
That's an example.
And what happens if you leave everything to one person and they are the power of attorney and they can say there's a conflict?
They don't get to decide whether there's a conflict or not. Yeah.
Well, I just want consultation.
Yes.
I'm not worried about the conflict.
I can't even consult with anybody without.
I mean, to make it an initial appointment, I just call and say,
Yeah.
I'm essentially working sometimes so well,
Yeah.
whatever.
Yeah.
And then they would just take it from there.
They would, yeah.
Okay.
So advanced directives are after death.
Now, advanced directives are in advance of your death. Those are things that will benefit you during your life.
Yes, but before death.
Yep.
What if you did a will 20, 25 years ago in another town? I don't even know if the place was in existence anymore. But none of it applies. You know, our children were smaller and things like that. Does that still stand until another one's made?
Yep. So you're.
But who would even know where it's at?
Well, there's legality and there's practicality. Okay, you asked me two questions.
Oh, I did?
Yeah. The legality of that is, yeah, that will is effective until it's revoked. Okay. Whether somebody finds it and tries to probate it is a different story. Okay. If someone never finds it, then they say, well, there's no will, and so she's intestate, so they would pass as if she doesn't have a will. I always advise people, if you have a will or a trust, review it once every 5 to 7 years, or if you have a major change in your life, review it to make sure it still says what you want it to say. If you did a will or a trust 20 years ago, you should probably talk to somebody. Okay? There's probably something that needs to change. Your personal representatives, who you want to do that, they probably changed. You know, how you want things divided. Maybe some of those beneficiaries that passed away will want that changed also. Okay.
Like 15 years ago,
Yeah.
you should be changing.
You should at least look at it and make sure it still says what you want it to say.
Sure, there's still somebody.
All right, well, I think that's about it. Any other questions?
Does joint tenancy work for your children?
You elaborate on it?
Well, like me and my son live together and I pass on, would it work for him?
It works. If you're trying to pass it along, it works. Again, that's one of those things I don't recommend because it's subject to his creditors, and he doesn't get a step-up basis at your death. You're costing him money. Okay, if you do a beneficiary deed instead, for the example that I had, a $250,000 house, his basis, if you just put his name on it, is zero. If he sells it, he's got to pay 20% capital gains tax on that. He just cost him $50,000. Or you do a beneficiary deed, and it costs, I think you charge $500 for a beneficiary deed. Pretty good value into this.
Your investment and how your beneficiaries would open it.
You have to do the whole side.
Do they just cash all that out and give it to your beneficiary because you're no longer alive?
If you have investment accounts that are invested in securities when you pass away, typically they don't just liquidate them upon your passing. They typically will say to the beneficiary, this is the account, these are the investments, and then they have to make that call.
Because some are locked in, some are not.
Yeah. Okay.
When are you going to do the thing for Medicaid?
I do not do that. That's right. I don't do Medicaid planning. I know enough to, when someone needs it, I can refer them to somebody who does do it.
So, will they give a seminar on Medicaid? Will they give a seminar on Medicaid?
I can look into that, but I can't say for sure without, I'd have to get an expert for sure.
Yeah.
So, I mean, that's definitely a good recommendation though, so I'll see what I can do.
All right. Awesome. Thank you guys for coming.
Yeah, thank you. I have another card for you.
Oh, sure. I don't know what happened to the card. Did you guys all get a card?